I am to shed light on the impact of the Nigerian Data Protection Act 2003 on digital and electronic documents. And I must say at the outset that considering the time frame, we cannot have a proper presentation. So I have decided to limit myself to the interchange of ideas to which this discourse was intended. The Nigeria Data Protection Act 2003 was enacted essentially to provide something like a legal framework for the protection of personal information and generally for the establishment of the Nigeria Data Protection Commission, which will be saddled with the responsibility of regulating the processing of personal information in Nigeria. Um, Before the enactment of the Act, um, privacy protection was under the supervision of the Nigeria Data Protection Bureau, and its operation have now been merged and subsumed under the Nigeria Data Protection Commission. We must bear in mind that what the Act seeks to protect is purely personal information. So this discourse will um, take a cursory examination of the relevant provisions of the Act as it affects electronic slash digital documents. Um, well, vis-a-vis its eventual usefulness or the eventual usefulness of such documents to a forensic expert. Um, we must bear in mind that majority of the data we have now are no longer in paper form. So, in considering the impact of the Act on digital or electronic documents, we should also bear in mind that the draftman of that act bore in mind. Hello, hello, hello.
Hello, sir.
Hello, sir. We can hear you.
Yes,
We can hear you, sir. We can hear you.
yes, sir. So I was saying that we must also bear in mind that the draftman of that act had in mind electronic slash digital documents because we are in the era now where we can hardly get a physical paper data containing personal information. Most of the data we have now are in digital and electronic form. That takes us to the objectives of the Act, the application of the Act, and the exemption. We should not forget that we have said that what the Act seeks to protect is basically personal information, which are largely now in digital and electronic form. So the objective, bearing in mind that the Constitution is the supreme law of the land, Section 1 of the Act says that because we, by Section 1, sub 1 of the Constitution of the Federal Republic of Nigeria, it says the Constitution is supreme and it is binding on all authorities and persons throughout the Federal Republic of Nigeria. Section 1 sub 3 states that any law that is inconsistent with the provision of the Constitution shall, to the extent of its inconsistency, null and void. So, bearing that in mind, Section 1 of the um, Nigeria Data Protection Act provides that the Act at all time shall safeguard the fundamental rights and freedoms and interests of data subjects as guaranteed under the Constitution of the Federal Republic of Nigeria. What that simply means is that the Act itself has recognized the supremacy of the Constitution and that all its provisions are in tandem with the provisions of the Constitution. So we cannot have a situation of contradiction or conflict of interest. That's what it simply means. Section 1B provides for the regulation and processing of personal data, while C promotes data processing practices that safeguard security of personal data and privacy of data subjects. Data subjects are individuals like you and I, to which the provisions of the Act apply. Section 1D ensures that personal data is processed in a fair, lawful, and accountable manner. Then it also protects data subjects' rights and provide means of recourse and remedy in the event of breach of the data subject's rights. So these, amongst other provisions, are the objectives of the Act. Meanwhile, Section 2 of the Act provides for the application. The Act says that the Act shall apply where the data controller or data processor is domiciled in Nigeria, resident in Nigeria, or operating in Nigeria. To my understanding, a data controller or data processor, although Section 65 of the Act defines who a data controller or data processor is. Going to Section 65 now, it says, I'm sorry, can you hear me?
Yes,
Hello?
sir, we can hear you.
Yes,
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 we can hear you.
Sir, we can hear you, sir. We can hear you.
yes, sir. It says a data controller means an individual, private entity, public commission, agency, or any other body who alone or jointly with others determines the purposes and means of processing of personal data. I am of the view that this definition is all encompassing, particularly regarding to a forensic expert. In this case, we can also refer we can also refer to a forensic expert as data processor or data collector. Um, it also says that the data controller or data processor is not domiciled in Nigeria, resident in Nigeria, or operating in Nigeria, but is processing personal data of a data subject in Nigeria. This section 2 talks about the application of the Act, and these are the categories of people to which the Act applies. The Act further provides for exemption of its application in section 3. What this simply means is that although by section 2 of the Act is applicable to these categories of persons, but in section 3, there are exceptions. And the exceptions are where the subject to the rights and freedom under the Constitution and the limitations, the obligations under Part 5, other than sections 24, 25, and 32. Personal data is carried out by a competent authority for the purposes of prevention of investigation. This is very much applicable to us. A forensic expert must bear in mind, for example, that where is investigation is for the purpose of prevention, detection, prosecution, or adjudication of a criminal offense or the execution of a criminal penalty. That is one. Secondly, where it is carried out by a competent authority for the purposes of prevention or control of national public health emergency. Thirdly, where it is carried out by a competent authority as is necessary for national security. Where it is carried out in respect of publication in the public interest for journalism, education, artistic and literary purposes, to the extent that such obligations and rights are incompatible with such purposes. So, um, by these exemptions, a forensic expert must always bear in mind that although the act generally applies, but there are exceptions. More often than not, we find ourselves in situations where we are saddled with responsibility of carrying out an investigation. So while we bear in mind the provisions of this act, we should also have it in mind that where it has to do with investigation, it does not generally apply to us. There are some things that are permissible. There are some things that are permissible. For example, for a data collector to make use of the personal data of a subject data, he must obtain the consent. He must obtain the consent of that data subject. He must obtain the consent of that data subject. But by these exemptions, if the purposes of collecting such data or collating such data is for investigation or prevention of crime, a forensic expert should know that in this regard, the application of consent would be needless because it does not require the consent of the subject matter because he's carrying out an investigation. Um, by section 3, sub 3 of that act, it says the commission may, by regulation, prescribe types of data and processing that may be exempted from the application of this act. And what that means is that the exemptions are stated in section 3.2 are non-exhaustible. They are non-exhaustible in that the commission has the power to expand the exemptions. The commission has the power to extend the exemptions in this act. Now, going to section 24 of the act, section 24 talks about guiding principles that a data controller, in this regard, like I said earlier, I have extended it to a forensic expert because the definition of data controller under section 65 of that act is non is all encompassing. Now, section 24 says that we must bear in mind, like the guiding principles that must be followed in data collection, that data must be processed in a fair, lawful, and transparent manner. So, as forensic experts, we should always let this guide us in our investigations, that any data we are processing must be done in fair, lawful, and transparent manner. Secondly, data must be collected for specified, explicit, and legitimate purposes and not to be further processed in a way incompatible with these purposes. I'm sure a forensic expert who is saddled with the responsibility of an investigation is given a brief. He will be given a brief as to the areas and the manner of there will be an instruction as to what that investigation is aimed at achieving. So a forensic expert, a data collector, must not go out of its way um, to do things that are incompatible with the instructions or brief that was given to him. Thirdly, is adequate, relevant, and limited to the minimum necessary for the purposes of which the personal data was collected or further processed. It must retain for not longer than is necessary to achieve the lawful basis for which the personal data was collected or further processed. It must be accurate, complete, and not misleading, and where necessary, kept up to date, having regard to the purposes for which the personal data is collected or is further processed. It must process in a manner that ensures appropriate security of personal data, including protection against unauthorized or unlawful processing, access, loss, destruction, or damage of any form of data breach. So, like I noted earlier, in processing or collecting data, these are some of the things that we are enjoined by Section 25 of the Act to always bear in mind. And I've also said, for the avoidance of repetition, the data in this regard has to do with personal information of um, data subjects. It has to do basically with data information. Now, going to section 25 and 26. Um,
You have 3 minutes.
oh, I'm so sorry. Going to section 25 and section 26, I can bring that together. I've talked, section 26 talks about consent. And what that means is that, like I've said earlier, you need the consent of the data subject before you can obtain or collect his or her information. Then, but it will not apply where it is for the purpose of legal proceedings. Where it is for the purpose of legal proceedings, it will generally not apply. Um, the essence of all this is to ensure that information regarding a person is not illegally or unlawfully tampered with. But at the same time, where it has to do with investigation, where it has to do with legal proceedings, you cannot totally, they are just general provisions with exemptions. Um, so by and large, I would say that although this act seeks to protect personal information, at the same time, that right to personal information is not absolute. It comes with its own exemptions. Thank you very much.